Hello everyone. In this video, we are going to continue the new forms of intellectual property. The next form is plant varieties protection and biotechnology. Plant variety protection and biotechnology are both facets of intellectual property law, offering legal protection to new plant varieties and biotechnological inventions, respectively. So, both new plant varieties and biotechnology can be protected under the intellectual property law. The plant breeders' rights protect new plant varieties, while patents can be used to protect the inventions in plant biotechnology. So, plant biotechnology, such as specific genes, transformation methods, or even transgenic plants. So, all these can be protected under the intellectual property law. Let us understand what is meant by plant varieties and biotechnology. Plant variety is a specific grouping of plants that have been bred or selected for certain traits like yield, drought resistant, color, etc. So, for suppose there is a rice plant which needs only less water and grows faster and gives high yield. So, this plant variety can be protected under the Plant Varieties and Farmers' Rights Act 2001, which provides a sui generis, that is, a unique system for protecting plant varieties, recognizing both breeders' rights and farmers' rights. Breeder is the person who have invented the rice and also the farmer's rights. So, both breeder and the farmer shall have the right to sell the new form of rice. But the farmers can only sell without the brand name. That is, for example, the brand name is Sona Masuri. So they cannot sell under this brand name, but they can sell the seeds and the yield without using the name. So it protects and prevents any other person from commercially selling the new variety of rice. Biotechnology means it is the use of biological techniques like genetic engineering, tissue culture, molecular markers. So, these are some biological techniques which are used for creating new plant varieties, which modify or improve plant traits, create genetically modified crops which are disease resistant or pest resistant plants. So, these modifications in the plants help the plant from disease resistant and pest resistant. So, the biotechnology can be legally protected through patents, plant variety registration, trade secrets. So, in India, genetically modified plants themselves cannot be patented, but the processes, tools, or gene sequences used may be patented under the Indian Patents Act 1970. So, the plant itself, the new variety of plant itself cannot be patented, but the procedure and the tools used for creating the new plant can be protected under the Indian Patents Act 1970. And the next kind of intellectual property is layout designs. So in the previous video we have understood that inventions under any field such as the medical and engineering fields can be protected under the intellectual property law. So layout designs comes under the electronic field. Layout design refer to a 3D arrangement of electronic components in an integrated circuit or semiconductor chip, which is governed by Semiconductor Integrated Circuits Layout Designs Act 2000. So, any creation of new layout design under the electronic field can be registered under the Semiconductor Integrated Circuits Layout Designs Act 2000. So, registration is only granted for original, distinct, and industrially applicable designs. By registering under this Act, it provides the right to sell, use, license, or prevent unauthorized reproduction of the design and also protects innovation in electronics and semiconductor industry. So, the intellectual property law covers wide aspects and inventions under various fields. The next kind of intellectual property is computer programs, a set of instructions or code that directs a computer to perform a task is called as a computer program, which is protected under the Copyrights Act 1957 in India as literary works. So, we have understood that there are many kinds of works which the copyright covers. So, Under the literary work, computer programs are protected. So the reproduction, adaptation, distribution, and modification rights rest with the copyright holder. That is who have invented the software program or the computer program. It protects developers from software piracy. So these are the new classifications of intellectual property. So I hope you all have understood it. That's all for this video. Thank you.